United States Supreme Court made a historic decision, effectively terminating affirmative action in colleges and universities nationwide. The ruling significantly impacting how schools shape their student bodies, alter the application process for prospective students, and determine funding for programs and campus initiatives. Moreover, it compels companies to reassess their recruitment and hiring practices, rethink their efforts towards diversity, equity, and inclusion, and overhaul corporate culture to enhance business goals. Here now, sharing more, is the founding partner of the Boyd Law Group, Patrick J. Boyd, and we are glad to have him with us. And Patrick, my friend, long time no see. Good to see you, brother.
Always a pleasure.
It's been a minute, but a lot has happened throughout the course of time as we talk about the Supreme Court ruling right here. A lot of people not surprised by it, even though it was a 6-3 majority decision there. First of all, let me, as a lawyer, your thoughts.
Well, I think one of the points you made is an excellent one. Just to start with, the courts, of course, have oral argument before they render their decisions, and it was pretty clear, based on the political makeup of the court and the questioning in oral arguments, that the court was likely to challenge and overturn or render unlawful the admissions decisions or standards for the University of North Carolina and Harvard. So while I think the decision is disappointing to many, I think it is a decision we saw coming for a bit of time, just in light of the way the oral arguments were held, the questions asked, and certainly the political makeup of the court at this point as well.
Yeah. And so we take a look. Let's walk through this here. It was 6-3, majority ruling there, and we found a couple of key statements that were being made. Justice John Roberts, in making his determination, said that, quote, applicants, quote, must be treated based on his or her experiences as an individual, not on the basis of race, end quote. But when we really look at what affirmative action was really about, it was about race, but it wasn't in the way that it's being made. It's the law, but it's not the spirit of the law.
Yeah, I would concur with that. I mean, what the court is doing is looking at a basic reading of the Constitution, which of course prohibits the consideration of race to the advantage or disadvantage of anybody. But the spirit of the law and the spirit of the affirmative action protocols, which have been upheld for decades now, right, it is not to provide sort of an integrated classroom by virtue of race, but an integrated classroom by virtue of experience. I think that the court would say that their ruling is still consistent with that. Indeed, what the judges said was, well, it shouldn't be a decision based upon race, but if a student tenders her or his application for admission, and in the course of that application describes their race, their challenges as to diversity and inclusion and as to getting a fair chance, in that essay can be considered a part of the makeup of the student itself, herself or himself rather, and as a result can be a factor in making the decision. So in some ways, the court is prohibiting sort of a box-checking mechanism of determining race and then trying to establish a classroom based upon it. But on the other hand, at least in the way the majority crafted the opinion, the understanding is not to discourage diversity, just to make it maybe a little harder to accomplish, if that makes sense.
Yeah, well, now we look at it and the law's been passed and we know where things go from here in terms of when we look at those persons who may have had an opportunity to get to the classroom, that won't necessarily be the case. And from my perspective, as I've shared with other people on other platforms, this isn't about the admittance of unqualified persons. These are qualified people that you want to see have an equal opportunity, which is what the spirit of the law was giving way to. You have people who say, listen, this decision has set the country back and has set students back for some time. How do you weigh in on the gravity of this decision?
I think your insight is a valuable one, and we don't have to guess at this completely, right? Certain states, including the state of California, took state-based initiatives to preclude affirmative action a while ago. And what we've seen as a result of those state-based steps is a decrease in the diversity of the classroom because, quite frankly, administrators are too concerned about being labeled as making the wrong race-based decision given the law. So I think the ramifications are going to be likely a decrease in the diversity in classroom, and I think that's an unfortunate trend, and I think most people would agree with that concept.
Yeah, you've got DEI, which is a huge part of the corporate makeup. And when you look at this decision right now, is there really a need for DEI when you've got a decision that's been made just like this? This is what some people are saying.
Well, I agree with you again, and I think our President Biden agreed with you as well in taking a position shortly after the decision, saying he strongly disagrees with it, and obviously he's not looking for any entity to operate in a way that is unconstitutionally just checking boxes on race, but the president is suggesting initiatives for schools and for the private sector and public sector and employment that will find ways to make sure there is a diversity of experience expressed in the classrooms and in the public sector. I don't think it's going to be an easy path. I think the path has been made harder, but I do think there are solutions, just not necessarily the simplest or maybe the most thoughtful would be another way of looking at it.
Yeah. But on one side, you've got this decision that affects colleges and universities. On the other side, there's another conversation being had about how this really plays out in the corporate forum and how this will play out in the corporate forum. How can we expect to see this decision play out corporately?
My guess, and it is only a guess, is that to a certain extent the private sector is going to do what the private sector wants to do and what is politically popular. And so to the extent that they have embraced initiatives to start with, I don't see the private sector putting the brakes on that. On the other hand, to the extent that there are members of the private sector, and of course it's a diversified private sector in terms of political viewpoints, those that want to be a little bit less diverse or that care less about diversity, are probably going to stick to their guns in that respect too and be emboldened in doing so. I think Warren Buffett not that long ago gave a presentation and he was talking about his board of directors being majority white, majority old, majority men, and said they're best performers and that's what he wants and that's it. So I think that political protocol and that political set of beliefs will be something that certain companies that felt that way to start with will be emboldened to continue to pursue and continue to express vocally and in practice.
Let me switch gears a little bit and talk a little bit about another Supreme Court decision when the Supreme Court decision has rendered its verdict when it comes to religious accommodation. Now, people may not be so familiar with the religious accommodation, so Patrick, why don't we take the time just for a moment for those who may not know what the law is all about. Let's talk about what exactly is religious accommodation.
Sure. Well, certainly just as a basic constitutional framework, the freedom to express your faith and the freedom to pursue your faith is an important aspect of our Constitution. It's part of the First Amendment, of course. And for a long period of time, starting with the initial civil rights initiatives in '64, there was an articulated standard that employers had to offer some accommodations to allow employees to continue to pursue their religious beliefs, whether that's to give them a chance to keep holy the Sabbath on Sunday, or whether that's to get a chance for prayer room breaks for prayers during the course of the day. Seventh-day Adventists have a different kind of scheduling requirement also. So the initial civil rights laws were to provide for a workplace that accommodated the pursuit of and integrity of one's religious beliefs. In the 70s, there was a case that sort of changed things a little bit and basically said that an employer is supposed to accommodate, but they don't have to accommodate a lot. In other words, they just need to give a sort of a de minimis accommodation to religious observance. So maybe they don't have to give somebody Sundays off. Maybe they don't have to give somebody time to go to a prayer room. And that was a sort of a tough change in the law, but a long-standing one. This Supreme Court decision just recently related to a postal worker. He wanted to keep holy the Sabbath. That is, he didn't want to work on Sundays. He was attracted to the Postal Service because of that. But as a lot of us know now, the Postal Service will do deliveries for Amazon. So the U.S. Postal Service was asking him to work on Sundays. He tried to transfer to a different department where he didn't have to work on Sundays. He did that, but then they had to deliver on Sundays in that department also. He said, please accommodate me. Don't we need to work on Sundays? They said, no, we won't. And so he was forced to resign. And the Supreme Court, at this time, in a unanimous ruling, 9-0, held that the Postal Service needs to provide meaningful accommodations so that people can continue to be observant of their faith and engage in their profession at the same time. So a meaningful decision that way in favor of accommodations to workers and their religious practices, to the extent that those practices may intersect with the jobs they have.
Yeah, and so with the unanimous decision coming out of the Supreme Court, how often do we see that?
I would concur with you that it's not as common as we would like, but it's a very bifurcated world and a polarized world. So I'm pleased to see that this was a unanimous decision. I mean, frankly, one of the things that was most, I think, made this case so compelling was the structure of the entity. The Postal Service has employees. The Postal Service has resources. For the Postal Service to argue that it's an undue hardship just to give, a religious worker Sundays off so he can observe the Sabbath strikes me as a tough argument to make. A small employer who maybe doesn't have the funds, doesn't have the employees, might be able to make a more compelling case, but the Postal Service didn't want to accommodate him and opened up the opportunity for the court to say that all kinds of accommodations should be given for religious freedoms, including breaks, schedule changes, interface of schedule changes with other people, and that's going to offer a lot more freedom for people to continue to pursue their faith in their jobs. It does regulate employers 15 employees or more, so it's not completely broad sweeping, but a lot of people will probably be a little bit more comfortable in articulating the need of their faith and expressing that faith in light of this decision, which I feel good about.
Yeah. We also have another Supreme Court decision to talk about, and that's the decision that affects free speech and LGBTQ rights, Creative LLC versus Elenis. And give us a little bit of a breakdown of what we saw here before that decision came down.
Sure. So the state of Colorado passed a law requiring that businesses not discriminate against people based on their sexual orientation. Lori Smith was a woman who was a web designer. She designed logos and those kinds of things. And she was also going to start designing and helping people plan and schedule and put online the advertisements for their weddings. The case came to light because an LGBTQ couple sought her services. Lori is a religious conservative and does not respect respect is not the right word, but did not want to provide that service to gay people because in her faith, a gay marriage is not a recognized marriage. So she did not want to design the wedding website and anticipated that the law would force her to. As a result, she brought this challenge to the law. And again, we had a 6-3 decision, but the 6-3 decision upheld her freedom to decline to help this particular couple in the planning of their wedding because of her religious and First Amendment rights.
Yeah, and seeing that wasn't a unanimous decision. We saw divided pretty much along the lines that we typically would see things.
That's right.
The ramification of which a law like this and the decision that was made, what can we see as the potential ramifications behind this?
Very interesting, and it's going to be very complex. At the end of the day, interestingly enough, Neil Gorsuch is the judge who wrote the majority opinion. He's also the one who wrote the opinion embracing gay rights in about half of the states of the United States that had not previously. So Justice Gorsuch has been on sort of both sides of the gay rights equation. In this case, the court was taking the position that Ms. Smith and her freedom to practice her creative work how she wanted in the way she wanted was more important than the opportunity for this gay couple to have her do the work for them. Whether or not that translates to a business owner's freedom to choose to serve, work for, contract with people that they don't agree with or not, and the ramifications of it are still to be determined. Gorsuch wrote, "The government may not interfere with an inhibited marketplace of ideas," quote unquote. And so the First Amendment cannot make Lori work for these people. Justice Sotomayor was very disappointed by this, and in her dissent wrote, "Time and again, businesses and other commercial entities claimed a constitutional right to discriminate, and the courts have stood up against that until today. Today, the court shrinks, period, full stop." So a local woman, Justice Sotomayor, felt very strongly that this was a wrong decision. And I think a lot of small businesses are going to be emboldened to try to serve different clients by virtue of this decision, and there's going to be a lot of litigation as a result.
Yeah, I got to get ready to get out of here in a few minutes, but I just want to get the opportunity to have you talk a little bit about this law, the the non-compete agreements happening here in New York State. A lot of people paying good attention to that. Real quickly, give us the breakdown on that one and where we stand.
Sure. So a lot of workers these days have a non-compete agreement that prohibits them from going to certain places after they leave their job, to the extent that the places may be places that are in competition with the places they're leaving. California prohibited these non-compete agreements, and now New York was looking to do the same thing. Legislature passed a bill on June 20th, and if the governor signs it into law within 30 days, any non-compete will be invalidated. That means if you leave one job and go to another, the job you cannot stop you from working in any place, even if the place you're going to is in competition with the place you've left. It's a meaningful freedom for employees, a meaningful freedom for the movement of labor, and one that's consistent with the federal initiative that our President Biden encouraged in an executive order about 1.5 years ago. Now, it hasn't been signed yet, but if it does, it's going to mean a lot of employees have a lot more ability to leave jobs and go to other jobs without fear of ramifications. So, to a large extent, it's a great decision, I think, for the labor markets and for the freedom of individual workers. One small note: the governor expressed support for a bill that was going to be doing this, but only as to lower wage workers. The law covers all employees, so I don't know if there may still be some tinkering with the bill or with the governor's decision on the subject, but a very important and momentous decision, and another place, quite frankly, where potentially our state is leading the way in adding freedoms for workers, which I think is something we can all feel good about.
Yeah, some will be paying very close attention to. Patrick Lloyd, we want to thank you so much for being with us. Patrick Boyd, who is the founding partner of the Boyd Law Group. If you want to find out more about him, but yes, in contact, you can get him at theboydlawgroup.com. And Patrick, thanks so much for being with us. All righty.
Great to see you again.
We're glad to have you. All right, taking a quick break. We'll be back with more right after this.